also for the other parties to know what the treated. So what like to see. Mr. Leroy, I think you have got. So what is the position as far as your activity is concerned?
Yes, that indeed gives us the insurance. However, there is the small matter of costs. Costs.
Well, costs can be carried over as application will be carried.
Yes, well, that is correct. It can be carried over, but we are concerned about being called to court, having to rush to court within 24 hours when perhaps yes. No, I readily concede that there's no prejudice if it stands over till next week.
Is any other submissions on this issue?
Yes, on behalf of the EFF, we have a substantive application. I didn't explain in full to your Lordship when I was explaining, putting ourselves on the record. What we seek, we've got a copy. What we seek the dismissal of the application by Mr. Van Rooyen, the applicant. And we also seek a substantive order directing the Public Protector to release the report. And I accept that your Lordship is not in a position to make a determination either that our application should be heard now or that it should be heard on Tuesday. But we would like to request an opportunity to address your Lordship why our application to compel the Public Protector to release the report ought to be heard and decided now and not next Tuesday. We have made a case for that relief in the founding affidavit, which I think our learned friends have not seen and your Lordship has not seen. The second point that your Lordship raised is whether or not these applications are similar. I think those were the terms used. In other words, today's application and Tuesday's application. The best answer to that question is that they overlap, but they are by no means identical. And for another reason, which is that Mr. Van Rooyen's situation, in a sense, is distinct. There are specific allegations relating to him, and those allegations are covered in his application. And there are different allegations relating to the President. In other words, it's possible to carve out the situation relating to Mr. Van Rooyen to the President, so that one should not easily fall into the temptation of regarding the two applications as one and the same. So we would suggest, with respect, that Mr. Van Rooyen's application has been brought today. There is no basis, as far as we can see, why they should get even an interim form of an undertaking up to Tuesday. We've cited the Public Protector in our papers as a respondent so that we can secure an order compelling her to release the report today. Her term of office comes to an end tomorrow. It is not clear as a matter of law whether or not she continues. I know they say that, well, the Public Protector as an office exists on a perpetual basis. But it's not clear to us what will happen to this report if the current Public Protector is no longer in office come tomorrow, Saturday. There is a substantial public interest that this report must be distributed. We have alleged in our founding affidavit that the incoming Public Protector has said publicly that she does not regard the situation relating to quote-unquote state capture as a matter of priority. So the AFF is significantly concerned about what actually will happen to this report if the current Public Protector leaves office. And that is not answered by a knee-jerk response that says, oh, well, the office exists in perpetuity. The office, I'm afraid to say, in this case, is intertwined quite significantly with the incumbent. So it is vital, as far as we are concerned, that your Lordship should hear the EFF's application to compel the release of the report, and to hear what legal basis exists why Mr. Van Rooyen says that the report should not be released, notwithstanding what the Public Protector has told your Lordship, that the report will contain no adverse findings relating to Mr. Van Rooyen. So why should they then get an extension to Tuesday before that application could be heard? And what, we ask your Lordship, will happen after Tuesday? A decision will be made, presumably on a final basis. Further appeals will be made. Precisely when will the public know about the contents of the report? So I say those things as precursors to suggest to your Lordship that at the very least, you should afford the EFF an opportunity to persuade your Lordship that the application by Mr. Van Rooyen is utterly baseless, and that in fact, what is competent is an order compelling the Public Protector to release the report, as she was planning to do today. She is no longer the Public Protector come the 15th of October 2016. We have no idea what the future holds, and this report should not be withheld from the public.
Absolutely. Well, before you sit down, bear in mind, I haven't seen a single shred of paper as far as your application is concerned. So we debate it on that basis. And I think, bearing in mind that the application is alleged to be so urgent, I need to put a few questions to you. It seems to me that your client's concern is that if the Public Protector is not ordered today to release the report, there's a possibility that it might not be released ever in future.
Yes. Yes.
Please, I think you should ask the people, if they are part of your group of clients, to behave in court. Otherwise, I will to allow them to come.
Well, I'm sure the attorney will express your Lordship's concerns.
Yes. Now, that is how I sum up the submissions that you have made thus far.
Yes, your Lordship is correct.
Is there a possibility, and I pose it in neutral terms so that everybody can hear, that if the report is in fact in a final format, I assume that, in other words, that it is not yet to be finalized, it is ready to be published. If I assume that, and there's an interim order to say that report should be kept safe, and if you then come later, whatever happens in the meantime, with your application to obtain an order to force the Public Protector's Office to release the report, then it doesn't matter when that report is being released during the term of the current Public Protector, or whether it is to be released in the term of the next Public Protector. The office will remain in place. So if the report is being safeguarded, and if you are entitled at some stage to ask for such an order, and such an order would be granted, what is the prejudice?
So there are two answers to your Lordship's question, and we, as your Lordship says, this is the hypothetical scenario, because your Lordship has not said papers. The one is that there is a substantial concern, and one must not overlook the substantial concern of the change of the incumbent.
No, but sorry, you don't follow. If there's an order to release, what choice will the Public Protector's Office have not to do so?
In that event, my Lord, then I'm with your Lordship. In that event, if there's an order compelling them to release the report on Tuesday, for instance, then it doesn't matter who holds that office.
So I'm just testing what is the prejudice. You tell me you want such an order today.
Yes.
But if the report is ready to be released and it will be preserved, why can't you ask for such an order next week, Tuesday, when all the applications have been put together, not formally joined,
yes,
and when they are being heard by the same court? And the other advantage of such a procedure would be that in the meantime, this application and the applications to intervene will get time to become ripe.
yes,
Because you still have to serve, I suppose, your application. We still have to assume that there will be an answering affidavit. After that, there will be a replying affidavit. And it's very optimistic to think everything will take place within the confines of court hours today.
Well, my Lord, we received Mr. Van Rooyen's affidavit in the evening of yesterday. We've got a full answer this morning. So he must also do a bit of running.
Yes.
But that is by the by. Your Lordship raises an important point, which is if there is an order for the preservation of the current report as it is, then perhaps that might allay our concerns to some extent. But I'll take a full instruction on that, but I take that point seriously.
It is just in the debate that I've raised this. Obviously, I must still hear other counsel on this issue as well. Anything else that you would like to submit?
Nothing from you.
My Lord, in light of the fact that your Lordship made reference to a potential assumption, may I read a factual situation to your Lordship? It's in the affidavit, which may assist your Lordship. The Public Protector in the affidavit that I have the answer regarding the report says two things. The first is that the Public Protector has already finalized and signed the report. Insofar as the applicant seeks to stop the Public Protector from finalizing the report, it's too late. So in other words, as we sit here today, there is a finalized and signed report. She goes on to say that it expresses no findings, point of view, etc. about the applicant, but as we sit here today, there is a finalized and signed report.
That's quite pleasant.
Sorry to interrupt. May I, just before you get to your feet, just have another few questions put to your colleague. What is the position of your client, the Public Protector, if there is interim-wise an order that this report, which you now tell me has been finalized, should be preserved pending finalization of whatever matter?
May I take a quick instruction?
You can do so
I'll
just
do that
now.
now. It shouldn't take me too long. If your Lordship can hear other parties, and as soon as I've got the instruction, I'll send it.
Thank you.
My Lord, hopefully to be helpful. Of course, I followed the exchange between your Lordship and my learned colleague. I'm exactly in the same position. I would like to say, my Lord, that on behalf of the UDM and Co, the second and third intervening parties, and in view of the fact that your Lordship has not even seen the papers, and we are indebted to your Lordship for entertaining, at least taking our word for what is in that application for now. My Lord, the suggestion of a preservation order of some sort seems to be attractive to us. I'm just going to, yes, well, I just had some sign language instructions, my Lord. The preservation order would your Lordship, it would be a practical solution in the sense that the report is the report. I do want to say, my Lord, that the question of the dissimilarities between the two applications is confined to the following. The application of Mr. Van Rooyen obviously says that the report should not be released insofar as it implicates him. And the President's application is for asking for time and so on to be given 2 months. We have had the privilege of seeing both applications, which is why we cited the President in this matter. And as it happens, now that they are here, they would be part of whatever solution we.
Both applications relate to exactly the same report.
Absolutely, there's no doubt. The same report, and even the sections of the Act that are being invoked are the same. There's no doubt about that. So our position would be, if there is a preservation order, then there should be no stumbling block to the matter being heard jointly at whatever stage. That's correct.
My Lord, I can report to your Lordship that the preservation order suggested by your Lordship is thought to be a prudent one, and the Public Protector accepts.
On behalf of the EFF, we would also accept the preservation order that your Lordship proposes.
My Lord, the interests of the DA are procedural. Depending on your Lordship's order in this regard, the DA just wishes to intervene in the matter as the complainant that gave rise to the report that we are speaking of, so there can be no doubt as to its locus standi. And it wishes to have its intervention recorded and requires copies of all papers and process filed in this matter to be served on its attorneys of record, if that is an issue which your Lordship would consider to include in any directives that you may order in due course.
Yes, I'm in full agreement with the preservation order.
You are in agreement?
Yes, we are in agreement. We're not trying to stop it. We just wanted to have our rights protected. And I haven't been served with any of the current papers as well, so if we could also be served with those papers so that we can answer and have the matter heard.
Mr. Du Toit, it appears to me that or perhaps I should put it this way, there appears to be a general consensus, but you still have submissions to make, I believe.
Yes, my lord. Firstly, I have difficulty with the concept raised on behalf of the intervener that the public protector who stated that she will not release the report today should be ordered today to do so. That seems to be beyond the scope of this court's jurisdiction, and certainly in an intervention which still has to be argued and which has not yet been answered or replied to. So I think that request is completely premature and certainly cannot be made to this court. Secondly, as regards what has been referred to here as a preservation order, the object, as I understand it, is to bind some future, the future public protector when she's not here. And that seems to be unfair to her. She has a discretion which she must exercise lawfully and in terms of her mandate. But I have difficulty with an order which binds somebody who is not here.
But what is the position if the Office of the Public Protector, who is being represented in court by a senior counsel,
Yes.
if that person comes to the fore and says, I'm prepared to concede to such an order, why should your client object?
No, I'm raising that. As far as we are concerned, the objection is related only to the implication, any implication there might be regarding our client. Our client has not been given the right to respond, a meaningful right to respond. He's been given 24 hours notice, and that certainly is insufficient.
Now that I understand,
Yes.
but the idea is, Mr. Du Toit, to let you have the application fully argued
Yes.
next week when this application is then to be heard together with the other one. Is there any objection to that procedure?
No, I've already indicated a postponement till Tuesday is certainly acceptable to us. No problem with that, my lord. My problem is with this new idea which has been floated here without any papers to support it, without any response, any application or response.
I understand that, but I think you should just bear in mind, I have to be practical as well. This is the urgent court. We don't have time as in any other court. There are many parties involved, and to get this application together with the other one, procedurally wise, properly be put before a court, I have to take into account certain interim measures which may be important. I don't say it is necessary, but it will satisfy, it appears, all the parties. As a matter of fact, there's an offer by the Office of the Public Protector to say, yes, you may make such an order without an application. Why should I now resort back to papers if there is an offer of that nature? I don't think it's necessary.
Lord, we have little doubt that if there is a signed report, which my learned friend said he didn't know about, but which now we see in the document is in fact in existence, if there is such a report, that it will be kept or preserved or maintained in the Office of the Public Protector. Yeah. There can be little doubt about that. And there would seem to be no problem with the fact that the report will continue to exist. My only point that I'm raising is that the discretion of any future office holder cannot be limited now by any order granted in this court when she's not present.
Well, we're not there yet, are we?
No, no. I'm only raising
Yes,
that
you
as,
just want to put it on record.
as a caution to any extensive order that may be sought or granted in this court.
Yes.
Thank
Mr.
you.
Du Toit, I think what should be best under the circumstances, if there is no formal objection, and I'm addressing you now because you are dominus litis, so to speak, representing the applicant before me. If there is no objection in principle to allow the parties, other parties in court to join themselves to this application. I'm referring to counsel for is it the DA and the EFF, etc., etc., so that this application can become ripe between now and next week, Tuesday, whatever it entails. Should I not allow the matter to stand down so that council can go and sit and prepare a proper draft order for this matter to be referred to the same court next week, Tuesday, 10 o'clock, who will hear the other application, and then you can also agree amongst yourselves what time periods for filing of affidavits should be applicable. Otherwise, if I have to sort out that, I think it will take a long time, and I still have other urgent applications to attend to as well.
Indeed, my Lord, that is the function of counsel.
Yes.
I just want to make one point clear. There's an intervention, an application to intervene. We received that, I think, this morning. Yes, I received it this morning. There is no, in our view, as it is formulated at the moment, no direct and substantial interest at all. It seems to us to be rather a publicity stunt on behalf of political parties. But that's not what this court is for. That direct and substantial interest has to be shown, and it's disputed at this stage on the papers which we have seen, and it's disputed, and any order will be subject to our right to object to any intervention.
Yes, in other words, I'm not going to make an order now for intervention.
As your Lordship
The
pleases.
idea is that you should sit together and agree upon the filing and the answering and the replying, so that that application or applications can then be part of the hearing next week.
Yes, I find the to do that between now and Tuesday, when there are 3 interveners, I think, or 4 possibly, interveners, a tall order for.
I'll discuss it with your colleagues,
Yes.
and I think in the draft should then also be incorporated the, let's call it, preservation order for the meantime.
We're busy writing something out which will run by the other parties.
Yes.
And hopefully come back to your Lordship with something which ought not to be contentious.
Yes. So what I now am going to do is I will take a short adjournment. It will allow everybody to exit the court so that it can be done in an orderly fashion. And thereafter, I will come back and hear the other urgent applications. And whenever council is ready to present the draft, you may come back to court. The court will take a short adjournment.